In a landmark judgment rendered last week on 12th May 2022 in the matter of PTC India Financial Services Limited versus Venkateswarlu Kari and Another, the Honorable Supreme Court has settled some key aspects of the law relating to pledge. JSA represented the appellant PTC India Financial Services in this matter, and I had the great privilege of arguing this matter with Mr. Maninder Singh, Senior Advocate. The question which fell for consideration in this case was whether mere invocation of a pledge by a creditor, such that the creditor is registered as a beneficial owner within the meaning of the Depositories Act 1996, amounts to discharge of debt even though there has been no actual sale. And in deciding this issue, the court had to consider whether the Depositories Act 1996, read with Regulation 58 of the Securities and Exchange Board of India, Depositories and Participants Regulations 1996, has the effect of overwriting the provisions relating to pledge as contained under the Indian Contract Act 1872. The Honorable Supreme Court has ruled that the provisions of the Contract Act, which is substantive and general law relating to contracts, and the Depositories Act, which is primarily a law relating to securities, must be interpreted harmoniously. In the context of the Contract Act, the court has reiterated that the right available to a pledgee to sell the pledged goods must be after reasonable notice, as envisaged in Section 176 of the Contract Act, and the pledger too has the right to redeem the pledge till actual sale by the pledgee, as envisaged in Section 177. The court has also noted that the Contract Act does not conceive of sale of the pawn to self. In this background, to resolve the conundrum, the Supreme Court has ruled that though the Depositories Act distinguishes between the registered owner, which is the depository, and a beneficial owner, that is the de facto owner, that does not lay down a rule which is contrary to Sections 176 or 177 of the Contract Act. Said differently, when a creditor invokes the pledge and becomes a beneficial owner in the records of the depository, this does not have the effect of sale of shares by the creditor. This is only the first step to enable the creditor to sell and transfer the shares in accordance with the Depositories Act and the 1996 regulations. After this first step, sale has to be made according to the mandate of Sections 176 and 177 of the Contract Act. This is a significant judgment for various reasons. One, it is the first authoritative pronouncement of the Supreme Court on the interplay between the Contract Act and the Depositories Act. It puts to rest the conflicting views which were being taken by courts and tribunals on the issues addressed in this judgment, and it will serve as a binding precedent in all those matters where borrowers attempted to evade their liability on the ground that mere invocation of demat pledged shares, pursuant to which a creditor was recorded as a beneficial owner in the depository, resulted in discharge of debt. The Honorable Supreme Court has so aptly held that the law of pledge is dynamic and must adapt itself in the context of the current commercial environment.